Hello.
Hi there, how are you?
Hi, Josh. Not too bad, thank you.
Perfect. Everything working well?
Yep. How do I put my PowerPoint slide onto the
So
screen?
at the bottom, if you
Yep.
move your mouse around, there should be a green arrow that's a share screen.
Let's have a look. Oops. Got a blue arrow.
Share screen at the bottom.
Yeah. Okay. Got it.
Yeah, perfect. We can see that.
Okay, good. Let me just hit the go button.
If you can, the switch. What is it?
Change them over, isn't it?
Yeah.
Yeah. So should be that one, I hope.
Yeah, we can see that. Good to go.
Excellent. And how many people have we got online, Josh?
So on Facebook, we've got just over 180 and YouTube 62.
Good work.
Well over 200 people watching this now. Which is with 3 days in, I thought people would be getting tired. I know I certainly am, but we're soldiering on.
Excellent. Good job. Good job. Okay. Well, I have the lunchtime or maybe post lunchtime slot then, before handing over to Hayley at 2:00. So I want this to be interactive if we can. I don't know if people can ask questions. Josh, is that possible or not?
Yeah. People can ask questions. What I'll do is I'll be monitoring those. Did you want questions during the talk or kind of 15 minutes at the end?
Should we save them to the end and see how we go?
Yeah. Well, I'll be monitoring it. What I'll do in a moment is turn my camera and mic off, and then jump back on 15 minutes before the end to run through those questions.
Okay, cool. Right. Well, good afternoon, everybody. This is obviously quite an initiative by Josh, which we're very happy to support from a BDRL consulting perspective. So title of my presentation is Commercial and Legal Considerations of Construction Contracts. We will probably focus on the JCT design and build contract though, because it's a fairly well-known example. So we'll go straight through the slides. So a little disclaimer at the beginning, both from a legal perspective, but also one about my presentation. So here's the legal disclaimer. Being a lawyer, we all have disclaimers that we're not obviously giving fact-based specific advice. This is just an overview of the contract. Now, I actually thought I had till 3:00 today as well to prep this, so I've jumped on 2 hours early. I actually have a whole bunch of slides that we might just jump around a little bit, but hopefully you kind of pick up some core messages. Secondary disclaimer, I may be interrupted by one of these two people. This big fellow is a little bit rowdy and may start barking, so if he does, apologies. Another one is Mrs. B, who may start talking to me, forgetting I'm doing a presentation. So outline a little bit about who I am and who we are, a little bit about how we generally support property developers, then into choosing the contract, how to sort of work through the contract, a bit of a summary, and then, as Josh said, questions at the end. So a little bit about me. So I actually studied my law degree in the UK, then I moved to Australia, went to university for another 3.5 years, did postgrad studies, and then I joined DLA Piper, which is a big global law firm, and specialized in major project infrastructure. So new mine sites, power stations, railways, pipelines, etc. So I did both transactional work and dispute resolution work. Then during the global financial crisis, I moved to a gold mining company, Barrick Gold, which is at the time the world's biggest gold miner, as an in-house lawyer supporting their procurement team. So working on anything from construction contracts, chemicals, aviation, drilling, security, and that was covering the whole Pacific Rim. So they had a $6 billion annual budget to play with. Then with itchy feet, I moved across the country to Sydney and left legal practice and went into commercial space and negotiated major electricity and gas deals. So these were deals that were sort of anything up to $500 million. Then I returned to legal with Chubb Fine Security, was promoted to move to Singapore, and then left Singapore in August 2016, which is when I returned back to the UK and created what is now BWL Consulting. So I've had quite a good career in terms of being overseas quite a lot, and obviously in the last sort of 3 and a bit years, I've been back in the UK. A little bit about BWL as a company. So we're essentially a dual regulated multidisciplinary firm. We provide support with submission of bids for government contracts. We're regulated as solicitors, and we're also regulated by the RICS because we provide QS and project management and employers agent services. So we try and support our clients on an end-to-end journey through the contracts life cycle, and so that's essentially what we do. So here we've got a little bit of pre-construction, construction, and handover. We also do dispute resolution, which is what I spend a lot of my time working on these days. So developers, we do a lot of support. We provide a lot of support in setting up the development itself. So that might be the acquisition of the land, setting up the SPV and the joint venture or the shareholders agreements. We draft options and promotion agreements and overage agreements as well. Obviously, we've got a good network of people that we deal with. We draft exclusivity and lockout agreements. I think that's what my colleague Hayley is going to be discussing at the end of my presentation. She's got the next hour. We look at heads of terms. So, you know, when you're thinking about that JV document, we help you put your heads of terms together. Obviously, anything to do with the land acquisition and the sale at the end as well. Legal charges, loan agreements, debentures, etc. And then contract management and project management is the construction consultancy part of our business. So throughout the presentation, I've chucked in a few starbursts just to remind people that we are here to obviously raise money for charity. So I've popped a couple of these slides in as we go, just as a reminder. So into JCT contracts, and the reason I've chosen JCT contracts is because of the demand of most lenders for developers to propose a recognized form of contract between the developer and the contractor, and JCT is obviously very well known. So I've chosen that because it's, you know, because of how frequently it's used. From my perspective, in drafting JCT contracts for clients, whether they're standard or amended, I get a lot of clients who come to me and just simply say, I want a JCT contract. And that's great. So we have a starting point, but JCT is an entire family of contracts. And on my next slide, I'll show you that in a bit more detail. But the sort of the key or the most commonly used versions of JCT contract are the ones on this particular slide. So the design and build contract. So, you know, lots and lots of people come to me and say, can I have a design and build JCT contract? The design and build contract is, if you like, one of the more complex, lengthy versions of a JCT contract. So it really is quite a nuts and bolts approach to construction contracting, and you know, the title gives it away as well. So it's design. So it's contemplating that the main contractor you're engaging with is responsible for design elements as well as the build elements, and because of that, you end up with more clauses, you end up with more pages, you end up with more words, and you end up with more complexity. So once you start to get into the JCT family of contracts, you start to realize that actually you can choose a JCT that's perhaps a bit more tailored to what your actual needs are. Major project construction contract is what it says on the tin. You know, it is for ginormous big developments, maybe even major infrastructure projects. So, you know, the sort of developers we deal with probably won't use this as much. Design and build, yes. But then we go down to the next level, which is the intermediate building contract, which can come in two forms, with or without design elements. So with contractors design, or just silent in terms of design. And this is sort of a slightly more basic version of construction contract. And then obviously we've got our minor works building contract, again, with and without design elements within it, but, you know, for, let's call it the most simple of building tasks. So on the next slide, and granted, this is probably not the easiest slide to see unless you've got a big screen with this presentation on, but these are the contract families within the JCT world. So at the top, you'll see it says framework agreement within a sort of turquoisey coloured outline, and you'll see throughout this slide that you'll see different coloured boxes. So each box and each different coloured box is a different contract. So essentially, you can follow your way through the through the chart and pick the contract you require by answering yes, no to various questions here. So you can see across the top, you've got management procurement, traditional procurement, design and build procurement, integrated procurement. So once you start to choose a procurement path, you can then end up picking a different contract, and you know, it's a good guide to choosing the right one. So yet again, just another reminder, that's what we're here for. So I think once you've chosen your contract, the science to the JCT contract, well, really, JCT contracts are available online. Right? Anyone can buy them, and I'm sort of doing myself out of work here, but they are readily available online to purchase, to use the JCT platform that's online to populate the contract details, the recitals, and the articles. However, I've had direct experience where the developer has themselves filled out the contract either incorrectly or in an incomplete fashion, and that has in itself created an issue when the building works are either ongoing or completed, and you've reached the end, and there's either a quantum of money in debate, or there's standards of workmanship in debate, or there's just the whole build itself hasn't gone as smoothly as people would like. So whilst JCT contracts are readily available and you can, you know, anyone can access and fill them out, there is some complexity to completing the sections that you need to fill out, and perhaps one of the biggest one of those is for example, insurance, and that's something that we'll probably get to later on. So the next few slides are really just about some of the key concepts within the JCT contract, and within that, sort of what you need to do to manage this contract effectively. So from my perspective, if you're a developer and you're choosing the contract to use, the contract is, you know, the rules by which the works are going to get carried out. So if you don't know the contract itself and you don't understand the mechanisms in the contract to do certain things, for example, if there's an extension of time, what is the process for permitting an extension of time? how do you pay the contractor? What's the process? If you fall out, what are the rules which you need to abide by to resolve the dispute? And the JCT contract will cater to all the different eventualities that can arise through construction. The criticism, perhaps, of a JCT contract is that to follow through a process on a particular issue, you tend to need to jump around the contract quite a lot. So it's not like it's issue contained. So you can't sort of say, this is my issue and this is the one particular clause that addresses that issue. It's normally several clauses in the contract to address an issue, and they're not all going to be located on the same couple of pages next to each other. So that's one criticism I have of the JCT contract, is that whilst it's great and it caters to everything, in reality, not reading it, not understanding it, you won't find it easy to administer. So some of the interesting things that we have to deal with in terms of commercial and legal aspects of contracts and JCT contracts is, how do we cater for change? So change being an omission of work, an addition of work, or a change in what work you want doing under the contract. And once you've decided that as a developer you want one of those three things to happen, you've then got to consider, well, what's the impact of the change on the ability of the contractor to actually construct what I want them to do within the time frame I've given them and within the budget they've got to play with. So it's critical that we understand how to manage change. So the underlying sort of the proposition within the JCT contract is that the contractor carries out and completes the works in a proper and workmanlike manner. So that's just like your baseline. So your expectation in engaging that contractor is that they're going to do what they need to do. They're going to follow the drawings. They're going to procure the items they need to buy. They're going to do it all on time. They're going to stick to the budget, and they're going to leave you a nice clean site at the end. However, the next bullet points in this slide are quite, when we deal with disputes, these are the sort of the issues that we really end up having to deal with. So that management of change, managing delay and prolongation, we're looking at relevant events, relevant matters, and then we're looking at how we value the work and how we pay for the work. So change is catered to predominantly in part 5 of the JCT design and build contract. And we've got the definition in clause 5.1.1. So a change in the employer's requirements which makes necessary the alteration or modification of the design, quality or quantity of the works. So it's exactly what I was saying. Are you adding, subtracting, or merely changing? And again, it goes on. The clauses then build on that underlying principle, and you get clause 5.1.1.1, and it becomes all very convoluted with the numbering, but it starts to spell out then that how the changes would actually take place. So one of the key issues in any change, there's an impact. And from a contractor's perspective, a change can be a great thing, because it can be a way in which a contractor can extract more revenue and profit from doing the building works. So if you set the contract up at the beginning lacking some detail around what the builder or the contractor is to deliver, and you start making changes, it starts being a time in that project's development cycle where the contractor starts rubbing their hands together, starts thinking, great, I can make some more money. On the other side, if you've set the contract up properly in the first place, then the change and the way that you manage change shouldn't lead necessarily to a particular cost impact on you. But the critical thing with JCT contract is, rather than having a program requirement in the contract, so with each activity set out in a Gantt chart or some sort of project management system, the JCT contract doesn't have a fixed requirement for that, and simply says the works must be completed by the completion date. And the completion date goes in one of the contract particulars at the front of the contract, and everything is pegged to that date. So when you make a change, you then need to think about changing the completion date. And to do that, if you instigate the change as the developer, called the employer within the contract, the onus is then on the contractor to give notice to the employer to detail what the cause and effect of the delay is, making reference to relevant events, which is a long list of defined events under the contract that give rise to an extension of time. And then they also need to tell you in their notice what actually the change in completion date should be. And then it's for the employer to give their decision back to the contractor in respect of that notice and in respect of whether or not they agree to the extension of time and therefore the change in completion date. So, as I said, that change in the completion date has to have a reason for it that's within the contract. And we've listed out here on this slide some of the main relevant events that are in the contract. So change, we've just sort of discussed change. So an instruction from the employer to do something different to what was originally planned. Works undertaken by a statutory undertaker. So for those who aren't familiar with that terminology, a statutory undertaker is gas, water, electricity. Exceptionally adverse weather. Now, you may or may not have a contract which refers to weather being a reason for an extension of time or change in completion date. But the key to it is always how it's defined. So if you're a developer with weather events being a cause of change in the contract, you would want it to probably be defined differently to what a contractor would, because from a developer's perspective, you're wanting the project to be run according to schedule and on budget and to meet your expectations. Perhaps to the contractor, they're looking at ways and to have wiggle room to obviously increase their potential revenue and profit. So how those terms are defined is quite key. Next bullet point down is necessary permissions, approvals of statutory bodies, so planning permission, conditions, etc. And perhaps, given that we're living within a COVID-19 environment, the last one, force majeure, is quite apt. Within the JCT world, and these relevant events are taken from the JCT contract. Within the JCT contract, you won't find a definition of force majeure. Now, the question then becomes, well, force majeure, people think it has a common meaning, and I guess the bad news is that it doesn't. The term force majeure is not defined in the common law, and it's deemed to be what we call a creature of contract. So if you're looking to understand what force majeure means, then and you don't define it in the contract, then unfortunately, if you turn to the courts for a definition, you're unlikely going to get any help. So whilst it's in the JCT contract, and whilst some people think that's great, it gives them comfort, from a developer's perspective, leave it as it is. And from a contractor's perspective, it's going to be a case of, I'm not happy with that. I want it defining as being some events. And that definition can take many forms. So it can be very broad, it can be narrow, but it's essentially what the two parties to the contract are defining that term as being. And again, just to reiterate at the bottom, employers need to communicate their decisions regarding any extensions of time. So you'll notice there's a change in language here. So just to go to the previous slide, you've got relevant events that are events giving rise to an extension of time. And here you've got relevant matters. And relevant matters are matters that have an effect on loss and expense, which is another issue within contracts. And here we've got some of the main relevant matters, which is, again, change, employer's instructions, delay in receipt of any permission or approval, or any impediment, prevention, or default by the employer. So by way of example, the effect of these clauses are more on the contractor than the employer. So these clauses are designed to act as a framework to how the contractor is going to make their claims for loss and expense. So we've acted for a developer recently in respect of a JCT design and build contract, so this particular one. And we were arguing over the amount that was being asked for in the final account. So that's the final account being the money that's been, the final amount of money to settle the entire build cost. One of the items of the final account was loss and expense. And the arguments were around whether or not the employer had caused an additional loss and expense by their, rather than it being their actions, it's actually their omissions. It's things they haven't done. So, how these terms are interpreted and how you actually follow the procedures are very critical, because in that case, the claim for loss and expense for something the employer had not done came after the point in time in which the contract said they had the right to claim. So these processes, these terms and these processes are all set out in the contract. And whether you're a developer or a contractor, the critical thing is knowing how to manage the terms of the contract, depending on which side of the coin you're on. Okay, payment. So for many, perhaps the most important aspect of the contract is payment. So how do we pay within construction contracts? And perhaps construction is a little more unique than other industries, because in construction it isn't simply a case of sending someone an invoice for something you've done. Primarily because we've got legislation that acts as a default position in the event that a contract doesn't have properly set out clauses that reflect the legislation. Secondly, the issuing of a VAT invoice within construction is not particularly normal. And that the reason for that is because you get obviously different VAT treatments on different activities. But not being a tax person, we won't go into that in any more detail. Ask Josh. So how do we get paid under a construction contract? Well, first of all, we've got to make a payment application. So the payment applications are typically a monthly cycle, and typically it's a document setting out what percentage of work has been done in that month against the items in what we call the bill of quantities. So the bill of quantities sets out all of the items that constitute the construction. Then you have a price against each item of the bill of quantities, and then when you make your application for payment as a contractor, you're applying for percentages of each item that you've completed in that month. So you make your application, and whilst the project is between the commencement date and the date of practical completion, which is something I'll talk about in a second, whilst you're within those two dates, your applications are interim payment applications, as opposed to the final application, which comes at the end. Now, the contract, and the JCT contract is relatively good at doing this. It sets out pretty closely to the legislation how the payment process is to be carried out. Now, there are perhaps more risks on the developer side here than perhaps the contractor side. Now, the reason I say that is because there are elements of the payment process that if the developer or the employer doesn't do something by a given date, it's very easy for the contractor to make a claim, normally through the adjudication process, to be paid. So reading the payment provisions in detail and understanding them in detail is both legally and commercially paramount for actually both parties, but definitely for the developer. So what the process is step one, make the application. That's the contractor. Step two, issue a payment notice. That's by the developer or the employer. If you don't do that, then the contractor's application becomes the payment notice. Then there's another date in time, which again is all set out in the contract, by which you issue a payment certificate. And the payment certificate is confirming the amount that's going to be paid to the contractor. So it's the developer or the employer's response to the payment application by the contractor. If the amount that the developer is prepared to pay is less than the amount applied for, then the developer must issue the contractor a pay less notice. Under the legislation, the pay less notice must be issued no less than 5 days before the final date for payment of the interim application. And that's critical. So that 5-day window, if that's what it is in the contract, that 5-day window, if you don't comply and you don't issue your payless notice 5 days prior to the final date for payment, what happens is that the application itself becomes the amount that you must pay. Now, what typically happens is a developer or an employer gets this wrong. It doesn't issue the pay less notice, which means the application becomes the default payment certificate, which means that the contractor then adjudicates on what's typically called a smash and grab basis for the value of their application. And it's almost impossible for the developer or the employer to defend that process. Now, there is a way afterwards of if there were particular issues within the why that happened, but there are ways afterwards which you can deal with this situation. But typically, because the legislation was drafted to ensure cash flow for contracting firms, they've made it deliberately onerous upon the developers or the employers in terms of that process, so that you will get adjudications for the application amount if you get this wrong. Now, final payment under the contract. Sorry, I was just checking. I haven't got another slide on this. Final payment is dealt with under the contract by way of another process. So, once you reach practical completion, you would then enter your defects liability period. Sorry, I mean, this is video. Do you want to say hello? There's 300 people. No. Sorry, that's the disruption number 3 that I didn't put in my earlier slide. So when you reach practical completion, you enter the defects liability period, typically 12-month period. The final account process can commence typically after practical completion is granted. So what you do is the contractor builds the project, reaches practical completion date, and says, "Look, I've done everything that I've been asked to do. Grant me practical completion." On the assumption that subject to minor defects, that everything is done, the employer or the developer then issues the practical completion certificate. There starts the defects liability period, which 12 months, sometimes 24 months. Once you're in that phase, you can then start to debate, and I call it debate, the final account. Now, in the JCT contract, this process of agreeing the final account is humongously swayed in favor of the employer or the developer. And the reason for that is that they have built timeframes into the contract that can make it possible for the final account to take up to 12 months to determine. So from a developer's perspective, this is great, because the developer's got their building built. There may be some defects remedies taking place, but largely everything's there. Potentially it's also able to be occupied. But in terms of cash, if the contractor has left a chunk of money to that final account process, in terms of cash flow, it can both massively impede the contractor but hugely aid the developer, because they will not necessarily need to pay the final account monies for a period of up to 12 months later. And that's reasonably unique to JCT, because other standard forms of contract don't allow that process. Other forms of contract, for example, NEC3 contracts, they don't have a concept of final account. Everything's treated as a monthly interim application. If you as a developer, don't actually pay your contractor, then apart from other remedies that are available, for example, adjudicating to get the money, you also have, under section 112 of the legislation, you have a right of suspension. So the contractor has a right to suspend operations on a site on the expiry of a 7-day notice. So if you don't pay, if the developer doesn't pay, then the contractor issues you a 7-day notice. If you don't pay within the 7-day notice, the contractor can demobilize some site and leave site until such point in time that the developer pays them the money. In addition to paying what's due, the developer then must also pay what is required to remobilize the contractor to site. So there's around payment within JCT contracts, there's quite a few issues there that if you get it wrong, it can be quite damaging to how well the project goes. Okay, so into what happens when it goes wrong, and obviously construction is an industry where disputes are very, very frequent. So within the JCT contract, we have, I guess, 4 processes. The first process is mediation. The second process is adjudication, and the third process being arbitration, and the fourth being going to court. So mediation can be a formal process, or it can be an informal process. So it can be as much as an independent third party, bringing the 2 people in conflict together to try and commercially resolve the matters that are causing problems. Adjudication is a more formal concept, and probably the most used dispute resolution method in construction, where the party who's aggrieved will refer a dispute to adjudication. So they issue a notice to the other party saying, we're in dispute and we're going to seek an adjudicator to resolve it. You pay your fee to the nominating body to appoint an adjudicator. The adjudicator, once appointed, typically has 28 days to determine the matter from the date of their appointment. Now that can rise to 42, but it depends upon the parties agreeing to any extension of time. And the adjudicator will typically provide written decisions, a written decision around the outcome of the adjudication, and the adjudicator will decide who needs to pay their costs. So it's a more formal process, and then arbitration is perhaps even more formal, and typically, depending upon the complexity of the project that's being developed, it's quite common for the arbitration provision to be deleted within the JCT contract. And I think the reason for that is that arbitration is historically a sort of a lower cost jurisdiction than going to court. Today, though, it can be as expensive as going to court, and I think a lot of parties see it as just being an unnecessary step on the journey to final resolution of their dispute. So they typically cross this out, and I don't know if you, if the guys listening in are familiar with this, but it's an article at the beginning of the contract, at the beginning of the JCT contract, and it does give you the option to strike it out or leave it in. More times than not, it's out. However, I've got a job on at the moment where this clause has been left in, and arbitration is close to being commenced. Let's just have a look. I don't want to talk too much about arbitrations. I'm also conscious of the time. So, by way of summary, before we open up for any questions, so BDL is obviously a multidisciplinary practice. We provide bid services, construction consultancy services, and legal services. Developers, so we provide support through land acquisition, setting up joint ventures, drafting construction contracts, managing projects, quantity surveying, resolving disputes, and then selling any developments at the end. In terms of setting up the contracts, so the JCT contract we've talked about today is obviously quite central to the whole relationship between the developer and the contractor. One other note I think that should be borne in mind, and perhaps people don't realize this, is that developments are more complex than just appointing a builder to build. So you will have legal relationships, contractual relationships with an architect, structural engineer, planning consultant, M&E designer, various other professionals. And depending on the complexity of the project and depending on which other professionals you need to bring in, and depending on the complexity of the design aspects of the project, just the JCT on its own and in isolation isn't really sufficient. You've really got to think about your relationship with each of the professional advisors that you've got and the contractor, and you've got to look at the risk holistically of and look at the relationship you need to have with each of the parties. So that's just something else to bear in mind. And again, it's something else that we provide quite a lot of advice on is, at the early stages of the development, before you've really got into it, have a good think about the size, the scope and the complexity of the project, who you need professionally speaking, who are the advisors, who are the consultants you need. Think about your relationship with them. Are you too close to the architect? Are you too close to your structural engineer? Are you relying too heavily on them? Because what if they get their part of the puzzle wrong? Who are you going to sue? Who are you going to pursue your claims against? Do you need somebody sat in the middle to be on your team to manage those people and manage the contractor? So, something that we do quite a lot of is education to a point of helping people understand how all the levers within construction operate. So we've talked about the JCT design and build contract. We've talked about other forms of contract. And we've talked about some of the key issues within the contract, example, variations, change, extensions of time. And we've talked a little bit about dispute resolution. And I think that's me done.
Perfect. Fantastic presentation there, Paul. We've got a couple of questions coming in. Let's have a look what we've got so far. So we've got, is the QS responsible for managing disputes?
No.
No, perfect.
And so let's talk about the QS. So
yep.
Is the QS appointed by A, the developer, or B, the development finance lender? And what is the role of the QS depending on the appointment? And there's almost a presentation itself in that, because there's probably a train of thought by some that they don't need to, that they as the developer don't need to appoint their own QS because the development funder has a QS on the project. Don't forget that the QS appointed by the lender is looking after the lender's interests. So nobody's looking after your interests over here. So if you appoint your own QS or your own PM, your own project manager on the project, then should there be a dispute, well, then the answer would be yes. They may be a first port of call to sort of work through the early stage negotiation to maybe crystallize a potential dispute. And depending on their background, they may be able to adjudicate, because there are QSs and the QSing practices who do the adjudication process. But that's down to that appointment. But don't expect your QS over here acting for the lender to do anything on your side.
Perfect. Fantastic answer there. What else have we got? So, what's the best way to avoid disputes kind of at the initial stage whilst engaging and also whilst in construction?
Okay. That's actually a really good question, because when you set the project up, and when you're setting up your contractual framework, and it really is, a framework of contracts between the developers, the principal on the project, the various consultants, and the contractor. When you're setting that framework up, how well you do your job there may well determine whether or not a dispute arises. And if one does, how easily is it to resolve it? Because the more gaps you have in the paperwork, the more likely you are to have claims from the contractor or claims from some of your consultants because you haven't administered the project effectively. So really setting it all up is paramount. Putting the effort in at the beginning it usually does pay off. Within the life of the actual development, so once we've got diggers on site, etc., understanding, if you don't have the skill set to project manage or do the quantity surveying part, understand the value of appointing someone in that role to manage those contracts with the various other stakeholders within the project. Because if you can manage your side of the contract effectively and encourage the others to do so likewise, then obviously if the contract is written correctly, then you'll obviously have hopefully a relatively successful project. But if you start ignoring your obligations under the contract and you start being a little bit loose around the administration of it vis-a-vis your contractor or your other stakeholders, then you're more likely to have problems and enter a dispute because you won't have done your paperwork properly, you won't have got site reports properly, you won't have photographs, and it's just much more difficult and more time consuming to then act for people in resolving those disputes.
Yeah, that certainly answers that question. So another question come through. So what would you do if the adjudicator found in the contractor's favour and the developer doesn't pay and saves no money?
So adjudicator finds in the contractor's favour, and the developer says he has no money. It's a very good question because, strictly speaking, if an adjudicator finds in favour of either party, the enforcement process of the adjudication outcome is to go to the High Court and to the Technology and Construction Court to get an enforcement order so that you can enforce what the adjudicator's decision is against the other party. Now, if the other party then goes into some sort of insolvency position, then you're very much going to be, confined by those insolvency processes. It can be difficult. If you've got, it depends on where you are in the contract cycle too. I mean, if you've got materials, etc., that you've purchased for the project that are on the site and haven't vested in the developer and haven't been incorporated into the project, then you can probably stake a good claim to go and get those back. For otherwise, I think you're going to be fairly hamstrung by insolvency processes, because typically, the JCT contract, for example, the rights in an insolvency event from the contractor's perspective is simply to terminate the contract and walk away, and obviously pursue other avenues for making up whatever losses they've suffered.
Yeah, perfect. So yeah, got time for a couple more questions, I think. What value of projects do you think it's worth JCTs being implemented?
Well, value is a good pointer in terms of which JC contract to use, perhaps, because logic says the higher the contract value, the more complex the project, and therefore use that as a guide. But the choice of JCT contract, it comes down to a number of factors. You know, one, obviously size of project. Two, requirements of your lender. If you've got a lender and they've set their requirements, it can be toolsome because they're going to dictate which contract to use. And then, you know, other aspects. For example, like I spoke about at the beginning, is there design elements in there, or is design done by the architect, the structural engineer, and the contractors only building in accordance with their drawings? So the whole choice of contract isn't a very simple answer, unfortunately. And you know, developers, you know, new developers who are just starting out the journey may turn to the JCT for some comfort, for example, because it's so well known. Whereas developers who are more mature and perhaps more sophisticated further down their journey may actually say, well, I do X number of developments a year. Can I have my own bespoke contract? And you know, I'm asked to develop bespoke contracts for developers who are doing numerous developments. So it's really not value driven in itself. It's just value is one guide to what contract to use.
Yeah, perfect. So I think someone's asked, what's the ceiling for a JCT minor works contract?
Sorry, Josh, say that again.
What's the ceiling for a JCT minor works contract?
The ceiling?
Yeah.
In terms of value?
Yeah, I'd assume so.
Again, it's sort of like, it goes back to what I just said regarding the other question, the question prior. You know, minor works is capable of being used almost on like a large domestic project, you know, like a large extension through to, you know, maybe 1 or 2 units. I don't think I'd be using it on, you know, a greenfield site for 20 houses. It's not going to cater to everything that you require it for.
Okay, perfect. That answers that one. So it's really just a case of speaking to somebody like yourself,
Yes.
and just getting the right contracts in place. Because with these things, there's very rarely a right or wrong answer. It just depends on 1,000,001 different circumstances. But thank you very much for your time, Paul. It's been a fantastic presentation, and I believe we've got your colleague now from BWL, Hayley.